We'll wait for just a few minutes and then start. Thank you for joining us, everybody. Okay, I think I'll start. Good evening, all. Thank you for joining us today. My name is Akshay. I'm the project director for Moneylife Foundation, and I'm delighted once again to welcome you all for an important RTI session. Before we start, for those of you who are new, this webinar is being organized by Moneylife Foundation. We are a 12-year-old non-profit organization primarily engaged in spreading financial literacy and advocacy for savers. We also make efforts to spread consumer awareness on various issues that are of importance to our members. Over the years, we have organized many sessions and workshops explaining the provisions of the RTI Act and also how to effectively file applications to seek information. We have also made efforts to provide counseling and assistance on RTI applications through our RTI Advice app, which is available to download both on the Google and Apple app stores. I'll share a link in the chat later. Today, we have former Central Information Commissioner, Mr. Shailesh Gandhi, to walk us through some of the common reasons and misconceptions under which RTI applications are rejected. And he'll also help us how we can counter such illegal refusals for requests of information. Many of you already know Mr. Gandhi, but allow me to formally introduce him. As I've said, Mr. Gandhi is a former Central Information Commissioner. He's also the first RTI activist to become such an Information Commissioner. He served at the Commission for 3 years and 9 months, during which he disposed of nearly 20,000 cases and also managed to completely digitize his office. After retirement from the Commission, Mr. Gandhi continues to remain active in all matters related to RTI and dedicates his time to helping citizens learn more about the Act. He's also present as an expert on our RTI Advice app, where he takes the time to answer queries on specific RTI applications. Before I hand it over to Mr. Gandhi, allow me to share a few ground rules for today's session. We have kept all of you on mute for the benefit of all involved and will unmute you only during the Q&A session. For optimal viewing, we suggest that you keep the webinar on speaker view. The meeting is being recorded and the recording should be uploaded on our YouTube channel, Moneylife TV. During the Q&A session, please use the raise hands button that is available on Zoom if you wish to ask any questions. Also, a sincere request to please keep your questions limited to under 90 seconds. Please feel free to use the chat section to share your comments, questions, and observations, but do send it only to the public forum, marking everyone. Please do not send us a private message, as we would not be able to monitor or respond while the session is live. Please also note that your cameras may be on by default and you could be broadcasting your background and homes for everyone to see. If you wish to maintain your privacy, you may turn off your cameras now. And without taking too much of your time, may I request Gandhi sir to please take over. So over to you.
Thank you very much, Akshay. That was very nice, a very generous introduction. Friends, people often ask me, a wrong decision has been given by a commissioner or a judge, what can we do? And I have no solution. And I'm not in a position to offer any solutions for this. Except to say that, let us look at the law. Let's develop legal arguments against wrong rejections and fight it legally. You can fight with logic. Despite that, there are authorities which have the power, and if they decide to do wrong, there's no help I can really offer. I get lots of phones almost every week saying, this galat decision ho gaya, kya kar sakta hu? Galat decision ho gaya commission ka, so the only option is going to the court, which is also an equally bad lottery. So I have no solution for that. All I'm hoping to do is to explain to you what are the illegal denials of information and how legally you can argue. Quite often people try and club everything and say there is a great public interest, there is great corruption. That doesn't help you. Develop the legal arguments, which is what to some extent I'm going to try and explain to you. Now I'll start sharing my screen. Is my screen visible, Akshay?
Yes, sir. You'll have to make it full screen.
Yeah, I'll try and do that. Okay, is this okay?
Yes, sir.
All right. What I call countering illegal refusals in RTI. Now, what is law and what is legal? My contention is what is given in a law is legal until it is ruled as ultra vires against the Constitution by a court of law. A court of law, so long as the law remains, has to interpret or go by the words of the law. And we'll take a look at some of the provisions and some of the wrong illegalities that have been committed. RTI is a fundamental right of citizens. This is something which is very important to understand. People say, I'll ban. Some people have gone and said they'll ban somebody from using RTI. They might as well say they're going to ban us from speaking, from publishing anything, which is absurd. Right to information is a fundamental right of citizens under Article 19(1)(a) of the Constitution, which guarantees freedom of speech and expression. This includes right to speech, to publish, to vote, and information. All these are covered under Article 19(1)(a). And I'd like to point out to you, because people say media is very important, therefore they must have a lot of freedom. The same freedom must be available to access information. In fact, more. There is nothing in the Constitution guaranteeing the media's independence or right to publish. It is derived from Article 19(1)(a), and the whole logic of it is that the media informs the citizens. So therefore, the citizens' right to information is paramount and is certainly equivalent to the right to publish. So those who say they'll ban people for life are committing a great blunder and not understanding the Constitution or the fundamental rights of citizens. The only permissible restrictions on Article 19(1)(a) are given in Article 19(2), which permits reasonable restrictions in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. Exemptions in Section 8 are to protect harm to certain interests and must be in consonance with Article 19(2). I draw your attention because the major illegal rejections are occurring by denying information relating to any natural person. And therefore, I want to draw your attention to the fact the only two words applying to privacy are decency or morality in Article 19(2). And if at all one has to look at it, one has to look at it from the perspective of the Constitution of India. On receipt of a request under Section 6, there are just two sections I'm going to draw your attention to. I'm assuming that you are familiar with the Right to Information Act. On receipt of a request under Section 6, PIO shall as expeditiously as possible, and in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in Sections 8 or 9. Only Section 8(1) and Section 9 can be used to reject. Section 9 covers copyright, which is a rare case, so I'll not deal with that. Section 8(1) we'll take a closer look at and look at the illegal rejections and how they are argued. When a request has been rejected under subsection 1, the PIO shall communicate to the person making the request the reasons for such rejection, the period within which such an appeal against such rejection may be preferred, and the particulars of the appellate authority. Reasons have to be given, and reasons cannot be just Section 8(1)(b), 8(1)(d), or one name. There have to be some plausible reasoning as to why information is rejected. And in my opinion, very rare information requests can be rejected if the law is followed properly. We have one of the best laws. We now have to safeguard it from marauders who are diluting the law and amending it without any sanction of the Constitution. Section 22 is also very important. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act and any other law for the time being in force or in any instrument having effect by virtue of any law other than this Act. In simple terms, if there is any law which is inconsistent in terms of giving of information, the RTI Act prevails. If some other law or rule says that this information shall not be parted with, including the Official Secrets Act, if the RTI Act, it is not exempt, it has to be given. The default mode, I repeat, in all RTI matters is that all information belongs to citizens. This is a democracy, we are rulers of this nation. And what has been defined in this law is not what will be given, everything will be given except what is exempt. This is extremely important to understand. Quite often people ask me, ye information milega, wo information milega. If there is an exemption that applies, then it is doubtful. But if no exemption applies, information has to be provided. Saying that something is confidential or secret or investigation is going on is no way to refuse information. Some illegal refusals. Returning RTI applications, refusal to accept RTI application. There is no provision to return an RTI application. I have seen a lot of rejections where people say, this information is available with a different department, please go there. Wrong. We are the sovereign of this nation and you cannot be given such an answer. The RTI application must be transferred to the right public authority by the PIO concerned. He cannot return it to you. Refusal to accept RTI application is also a violation of the law and must be fought. Refusal claiming confidentiality or third-party information. Quite often I have seen, this is confidential, hence it will not be given. This is sensitive, then therefore it will not be given. This process is not over, therefore it will not be given. Or third-party information. Third-party information is not exempt under the law. The law did not specify third-party information in Section 8.1. And very clearly, as Section 7.1 says, only Section 8 and 9 can be used to reject. All other things are procedural and cannot be used to refuse information. Refusal claiming information belongs to a different department or organization, which is returning RTI application or refusing. Wrong, not as per the law. It is his job to find out the right person. Sometimes I heard the argument from government officers saying, how do we know which department? If the government cannot arrange its matters in a fashion that almost every public servant knows how to locate which department is applicable, how can a citizen ever find that out? Transfer of application can only be made to one public authority. In transferring of the RTI application provision, the word uses public authority. Therefore, some commissioners have said it means only one public authority because this is singular, plural is not employed. The General Clauses Act makes it very clear that when reading any law, singular includes plural, plural includes singular. Similarly, gender, if it is him, it includes her and vice versa. And on this, I have given an order which you can refer to if you like. I'm giving order numbers here. These orders would be available on the CIC website. Alternatively, they would be available from Moneylife website also. 5 is information disclosure barred by the rules of the public authority by some other law. This is a common thing which Section 22 was clearly made to ensure that this does not happen. If something is inconsistent, then the RTI law prevails. If something is consistent with the rules of a public authority, then also there should be, the choice should be with the citizen which route to take. Incidentally, this order that I have quoted here, I think I have mentioned that even for income tax or taxation purposes, the Supreme Court has ruled that if there is more than one route available, it is the citizen's choice to decide which route to take, even if there is a revenue loss for the government. Surely in giving information, RTI is ruling supreme. I've seen some arguments saying just the mere fact that we have provision of rules to give information is adequate and therefore we will give only by our rules. Wrong, not as per the law. The law nowhere says anything like this. Clearly, if there is more than one route available, it is the citizen's choice which route to take. These are the exemptions of 8.1. 8.1 has 380 words to be precise. If you understand this, you understand what can be rejected. All the rest must be given to you. Default, the whole world is available to you. Now let's go through this and I'll point out the illegality of what they do. Information 8.1a, information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relation with foreign state or lead to incitement of an offense. Illegal refusal. Not quoting, this is a wide area. Quite often, they just say 8.1a. How are you to argue in your appeal whether it is sovereignty and integrity of India, whether it is security, strategic, economic interest? What is the rejection due to? What is the denial due to? In the order that I have quoted, this was Western Ghats ecology project given to Dr. Madhav Gadgil. For 2 years, Dr. Madhav Gadgil labored on this and then submitted a report to the government at that time. Everything that I'm referring to at the government and my period is 2008 to 2012. The environmental report was not being adhered to and not being published. RTI, somebody sought this information and the PIO just said 81A. I said, what interest in this is heard? Ultimately, it came around to that only the economic interest was his contention, which I argued cannot be heard, and environmental things must take precedence. And this was upheld by everyone. Expressly forbidden by a court of law, 81B. The respondent has refused to, this is, I'm quoting from the decision itself. Effectively, the PI has stated that since the matter is sub judice, he is claiming exemption under Section 81B of the RTI Act. This is quite often a mistake. Calling 81B denial based on the fact that the matter is sub judice. Parliament knew the word sub judice but did not use it. Information which has been expressly forbidden to be published by any court of law or tribunal or the disclosure of which may constitute contempt of court. If anybody uses this, ask them to show you an order. A legitimate denial would include an order of the court or tribunal saying that this information is not to be shared publicly. Unless that is done, this denial is illegal, and I am using the word illegal with full responsibility. What is not as per the law is illegal. Breach of privilege of Parliament or state legislature. Actual case of mine as a citizen RTI applicant. The other housing scandal is well known to people in Mumbai at least, and maybe the whole of Maharashtra and the whole country. An inquiry commission was set up to inquire into the matter, and the commission report came after 2 years, which held certain political people as well as some bureaucrats responsible. Government did not want to share it, therefore they put it under the table. The Commission of Inquiry Act requires that within 6 months, the report must be shared with the legislature, which the government did not do. And nobody was bothered, including the opposition then. I may point, and this is what I asked for after 6 months or over. And I argued that I may point out that exemption under Section 81C cannot be claimed to deny information. As per Section 3(4) of the Commissions of Inquiry Act, the appropriate government shall cause to be laid before each House of Parliament, or as the case may be, the legislature of the state, the report, if any, of the Commission on the inquiry made by the Commission under subsection 1, together with a memorandum of the action taken thereon within a period of 6 months of the submission of the report by the Commission to the appropriate government. Since this has not been placed within 6 months before the legislature, the breach of privilege of legislature has already occurred. It cannot now be claimed that giving the report to an applicant would cause a breach of privilege. The first appellate authority also rejected this. I went to the Maharashtra Information Commission. Before my case was decided, the government decided to place it on the floor of the legislature and gave me the report. All commissions of inquiry reports can be obtained after a 6-month period is over. No longer can these be hidden. It is your money by which the report is made, and therefore you have a right to it. I keep repeating, the fundamental approach to RTI is that I own the government individually. You are the Baksha or Begum of this nation. If you are the Baksha or Begum of this nation, if you are the sovereign of this nation, nothing can be denied to you. However, to run a nation, some limitations have been put, which have been mentioned in Article 19(2) of the Constitution and have been specified in Section 8(1). Beyond this, nothing can be denied to you. Trade secrets or intellectual property, the disclosure of which would harm the competitive position of a third party. Now, quite often people say this is commercial confidence, therefore we will not give it. Claiming exemption on the ground that it is commercial confidence is wrong. It must be shown that it will result in hurting somebody's competitive position. For example, once a tender is awarded, this cannot be claimed because nobody's competitive position can be hurt. I've seen people claiming that agreements are made between the party and the government when an order or work order or something like that is done, which claims confidentiality. Can such an agreement be legally valid? The answer is no. Just by saying that this agreement is confidential, it cannot be excluded from the RTI Act. And this must be shared with you. An agreement saying this is confidential cannot be denied to a citizen. And I think this agreement, this decision covered that. Information available to a person is fiduciary relationship. There is a larger public interest override, which I'll deal with a little later. Illegal refusal. Claiming information given to government is given in trust. RBI, passport applications, job applications, psychiatric. Most of this information is not given in a fiduciary relationship. Psychiatric, I'll deal with a little separately. Most information with the government is given in discharge of some statutory duty or some statutory requirement. The RBI has claimed fiduciary relationship with banks, which has been denied by the Supreme Court. 10 of my orders had denied this claim. The RBI went to the court challenging all of them, and the Supreme Court in December 2015 gave an order saying that the term fiduciary is being used to terrorize citizens. It's a very strong language use. And that information that RBI holds on the banks is not held in fiduciary, it's held in statutory consideration. Similarly, passport applications, job applications, etc. All these come under fiduciary. Now, a patient-doctor relationship is fiduciary. Therefore, psychiatric treatment must be treated as fiduciary. However, there's a very interesting dilemma that I was faced with in dealing with this case. A lady had sought information relating to her treatment in a psychiatric hospital. PIO denied it, saying it's fiduciary. The PIO's contention was that the information regarding her was given by the husband, with whom there was evidently some dispute. And the lady appeared to be quite capable of handling the information. There was no problem with that. So the issue was, is the husband the person whose fiduciary relationship must be honored, or the ladies? I had ruled that since the lady appeared to be competent enough to argue and understand the issue, she had a right to that information and this could not be denied. Information received in confidence from foreign government. For example, the Rafale deal information was refused by the government, saying it's given in confidence from foreign government. When information is from foreign government and it is claimed that it is in confidence, nothing further can be done. There is no argument about it. One has to accept the government's position on it. And that is understandable because otherwise I think foreign relations would be difficult to manage. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. There is certain information which at times would endanger somebody's life or physical safety. This kind of information would be denied. But I've had departments coming and saying that I will not give information about what a superior has commented on a junior because it will apply. I used to argue with them that do you really mean that your employee will go and beat up his boss because of some observations? They would say yes. I would say in which case your department must be full of gundas and badmashes. This must be given when there is some reasonable likelihood Supposing somebody is given information regarding a mafia don or something which only he could have the information. Such information should not be shared. Information which should impede the process of investigation or apprehension or prosecution of offenders. Ongoing information quite often is refused, saying that this would impede the process of investigation. Or in fact, they write clearly, information cannot be given because the investigation is ongoing. Wrong, absolutely illegal. Parliament could have said ongoing investigation information shall not be given. What Parliament said is, which would impede the process of investigation or apprehension or prosecution of offenders. Therefore, a PIO is to show how giving the information would impede the process. A very common occurrence is a person has filed a complaint regarding some wrongdoing, and he knows that no investigation is happening. And he seeks information saying, please tell me what investigation is going on. And the PIO claims 81H. Absolutely wrong, because it would be laughable to claim that the person who's made the complaint is going to impede the process of investigation. Of course, now we have a peculiar thing which many of you may not know. We've perfected the Protection of Corruption Act. Investigations cannot be carried out by Anti-Corruption Bureau. This, apart from the RTI I'm talking. Investigations cannot be carried out by the Anti-Corruption Bureau unless the government allows them to investigate. So for each case of suspected corruption, ACB has to ask the government for permission, saying, can we please investigate? If they give permission, then they can investigate. If they don't give, which happens in most cases, nothing can be done. Refusing information on the grounds that investigation is ongoing is illegal and not as per the law. The law clearly does not intend to exempt that. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers, provided that the decisions of councils of ministers, the reasons thereof, and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. An interesting case was a bill had been presented to Parliament by the government, and somebody had sought a copy of the cabinet note and the deliberations of in the ministry regarding this bill. The PIO denied, said 81I, it's a cabinet paper, record of deliberations, etc. But he had not read the second part, which puts the duty on the government to share the information regarding the reasons thereof and the material on the basis of which the decision was taken publicly. Therefore, I had ruled that within 7 days of any bill being presented in Parliament, the cabinet note and the reasons thereof and the discussions on this must be made public within 7 days of presenting any bill in Parliament. The government followed that for a few months, but after a few months they went and challenged it, and now I think the matter is in some court. The most popular with all PIOs in the government now is information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the public interest, larger public interest we'll deal with later, provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. This has become the favorite for everybody because of gross, I'm saying gross misinterpretation. It's not even a misinterpretation. It is just amending the law blatantly, brazenly, which is very sad. And this is what I am hoping. According to a CHRI study at that time, which was made about 2 or 3 years back, 35% RTI applications were rejected based on 81J. Now, from what I hear, it appears to be rising. And let's understand what this means, what Parliament said. Information could be denied if it was personal information, but just because it's personal information, it cannot be denied. Otherwise, Parliament would have just said personal information unless there is a larger public interest. And disclosure has no relationship to a public activity or interest. Ask yourself, how does information with the government come about? Most of the information is the consequence of a public activity. And what it generates is a public record. Or it is unwarranted invasion of the privacy of the individual. Now, this is another thing which is, privacy has been declared as a fundamental right by Puttaswamy judgment. 9 judges have delivered the judgment. You read the judgment, and you cannot find any definitive guidelines as to decide, saying, okay, activity A, B, C, D is what it involves privacy. It gives a lot of theories and philosophies, and basically says that issues of what is covered by privacy would be decided on a case-to-case basis. Parliament realized that it would be difficult for a PIO to decide what is issue of privacy. Therefore, it gave an acid test to this 81J. Provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. This proviso is given only for 81J, which means if something is an invasion of privacy, then it should not be given to Parliament or state legislature. It should not be given to a citizen also. If it can be denied to Parliament, it can be denied to a citizen, accepted. What can be denied? The only permissible restrictions in Article 19(1)A are given in Article 19(2). I come back to this. 2 words relating to privacy in this. Only 2 words, decency or morality. I do not believe anybody can say sovereignty and integrity of India is linked to privacy. The security of the state is linked to privacy. If something violates decency or morality, then information should not be given to Parliament. Information should not be given to a citizen also. This simple thing has been turned into a monster by, as I explained. Now, before that, let me deal with R. Rajgopal Supreme Court judgment given by 2 judges in 1994. The ratio decidendi clearly is, incidentally, a Supreme Court judgment or a High Court judgment is a precedent which has to be followed only in terms of the reasoning, legal reasoning given, and what is called the ratio decidendi. Everything that is written in a judgment does not have to be treated as a precedent. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, amongst others. Mind you, this was much before the RTI Act, but privacy doesn't change. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or not. What applies to publishing applies to to freedom of speech, applies to right to information. Second point is very important. Once a matter becomes a matter of public record, the right to privacy no longer subsists and it becomes a legitimate subject for comment by press and media, amongst others. We are, however, of the opinion that in the interest of decency, Article 92, an exception must be carved out to this rule, which is a female who is a victim of sexual assault, kidnap, abduction, or like offense should not further be subjected to the indignity of her name and the incident being publicized in press or media. It categorically states that what is a matter of public record, what is held by public authorities are public records, 99%. Only in some cases, what is not a public record may fall in the lap of the public authority. And number 3 is extremely important. In the case of public officials, it is obvious, right to privacy, or for that matter, the remedy of action for damages is simply not available with respect to their acts and conduct relevant to the discharge of their official duties. Commissions, courts, PIOs, and first appellate authorities are brazenly amending the law illegally and unconstitutionally, is my contention. I have again explained this, and all personal information is not exempt. A lot of decisions of commissions and others say this is personal information and therefore it's covered under Section 8(1)(j) and therefore information will not be given. How they are misreading this, I am showing. Information which relates to personal information, unless the PI satisfies the larger public interest, justifies the disclosure of such information. Very often, rejections based on 8(1)(j) say this is personal information covered under 8(1)(j) and there's no larger public interest in disclosure. They forget the proviso, they forget relationship to any public activity or interest, or whether it is unwanted invasion of privacy of the individual. All this is skipped. Whenever government has wanted to amend the law, the RTI Act in particular, citizens have protested vehemently. Once, 3 times in the previous government, in the UPA government, and twice in the current government. Once the government did not push it through. Second time they pushed the amendment through. But that did not affect the exemptions of the law. That only changed the perquisites and the term of office of the information commissioners. The government took it up. It was not a very good thing to do. But I must concede that this is far more serious. Only Parliament is authorized to amend the law. Nobody else, no court of law, in my opinion, can amend the law. And they are reading this law just like this. Information which relates to personal information. And there's no larger public interest, hence it comes under 8.1J, which is completely illegal and unconstitutional. And this is curb on a fundamental right of citizens. The privacy argument. Let's look at it from another perspective. Does the government have the right to violate the individual citizen's privacy routinely? What is on government record? Is it, when government seeks that information, is it violating the individual's privacy in a routine manner? To my mind, the answer is obvious no. If it is violating privacy, this must be opposed. But once the government takes that, it is public property, it is public record, which according to Raj Gopal's judgment must be available to everybody. Hence, most information which government takes in routine manner, public records must be assumed to be not violating privacy. This has been reiterated by the Raj Gopal judgment when it states, once a matter becomes a matter of public record, the right to privacy no longer subsists. And please understand, once I was arguing this and one retired judge said, Mr. Gandhi, do you mean to say tomorrow I'll be asked what I eat at home? The answer is no. What you do in your house is not a matter of public record. It doesn't have to get. However, if you eat in a restaurant and the bill is submitted to the public authority, and that is part of the record, then it's a public activity and there is no privacy of that. What you eat in your house, unless the government is paying for it. The RTI one can only seek what is on record. Hence, personal information collected routinely must be recognized as not violating privacy unless it violates decency or morality. Sexual preferences, issues of rape, things that would be termed as obscene. For example, in a raid on somebody's house, they may get photographs which were private. Now, the record may be held by the government, but that is not something that should be shared with citizens or with Parliament. And this must be the acid test which must be applied. Whoever denies information under 8.1 must state that he would not give this information to Parliament or state legislature, and hence he is denying it to a citizen. Member of Parliament and member of legislature get legitimacy from you, the voter. You, the citizen of India, are the person who legitimizes all this government record. Without you, there's no government, there's no democracy. Now, another very funny thing is there are things mentioned specifically under 4.1b, which must be shared publicly, suo motu, which also, under the present circumstances, is being denied quite often. Every public authority to publish within 120 days from the enactment of this act the monthly remuneration received by each of its officers and employees, including the system of compensation, is provided in its regulations. Quite often, this information is being denied, claiming 8.1J. The manner of execution of subsidy programs, including the amounts allocated, details of beneficiaries of such programs. Again, there are instances where this is denied. Particulars of recipients of concessions, permits, or authorizations granted by it. We are all aware that there's a lot of ghost names in such matters, and a lot of corruption takes place. The ability of RTI to destroy corruption, to curb corruption, is being curbed by misusing Section 8.1J. all DOPT's office memorandum of 15 July 2013 said all transfer orders were publicized through the website or in any other manner listed in section 4.4 of the Act. This is also now denied if people say details of transfers of from one office to the other. Section 8.1J, personal information. Parliament did not intend to exempt all personal information. There are countries in the world that have exempted all personal information under a similar clause. Parliament went to the trouble of putting in additional words so that it became a very restricted thing, and that is partly because of the fact that there was an attempt to curb corruption and wrongdoing in government jobs. People without merit get government jobs. People who have negative remarks in their annual confidential reports get promoted and overtake others and so on. And this is a fairly common thing. When I was in Delhi, I remember one case, doctors in government hospitals, somebody had sought their degree certificate copies. This was being denied under 8.1J. I ordered it to be given. The matter that once the certificates were given, the applicant discovered that some were from fake universities. So they were doctors from fake universities or what was not a recognized university operating in government hospitals. DOPT refused total number of annual performance appraisal reports of IAS officers pending presently for over 1 year, 2 years, 3 years. No names were asked. This is my own RT application, claiming exemption under 8.1J. They said you are asking information regarding some persons. Therefore, it's personal information and therefore information is denied. The request of benefits for details of MLA funds were denied, saying it was personal information. Details of beneficiaries of PM fund, amount spent on Amit Shah's, and so on and so forth. There is a Supreme Court judgment which goes in the name of Girish Deshpande, in which the Supreme Court, without any discussion, has said that personal information can be denied under 8.1J unless there is a larger public interest. And this is now becoming the gold standard and being applied, and it's expanding like a virus. Everywhere this is being quoted. And if this continues at this rate, all we'll get is budgets and nothing else. Anything related to a person is personal information. If I write a letter, it's personal because Shailesh Gandhi has written it. Anything that you can relate to a person is personal. But that was not Parliament's intention, because RTI was sought as a citizen empowerment tool and as a tool by which corruption would be constrained. Now, Section 11 is another one. Section 7.1 did not mention Section 11 as a denial of information. Section 11 is a procedure, which is being misused, and information is often being denied, saying it is third-party information. Let's read this carefully. Where a PIO, as the case may be, intends to disclose any information or record or part thereof on a request made under this Act, which relates to or has been supplied by a third party and has been treated as confidential by that third party, the PIO shall, within 5 days from the receipt of the request, give a written notice to some third party of the request on the fact that he intends to disclose the information or record, and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed. And such submission of the third party shall be kept in view while taking a decision about the disclosure of information. What does this mean? It starts with saying intends to disclose any information. That means the PIO has come to the conclusion that this information is not exempt and the information exists. Then what is the purpose of this? He must tell the third party that I intend to disclose this information, and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed. It does not give the third party a veto, and it says such submission of the third party shall be kept in view while taking a decision about disclosure of information. The whole purpose of this was, it was felt that exemptions are to safeguard certain interests from being hurt. It was assumed that the PIO will think of the interests of the third part of the public authority, but may not be as conscious about the interests the hurt that may happen to a third party. Therefore, this is a process to give the third party an opportunity to point out that the PIO's first answer was wrong, first determination was wrong, and therefore he must reconsider it. The PIO can only deny information based on Section 8 and 9 and nothing else. Supposing a thing is copyrighted, the PIO is unaware of it. Then the third party may say this is copyrighted, therefore you can't give it, and the PIO will have to change his view on this. Illegal refusal, refusing disclosure on the ground that it is third party information or third party has not agreed to disclose. Section 11 is not an exemption. It is a procedure to be followed to give the third party an opportunity. What happens if the third party doesn't respond? Information has to be given because the fundamental right of the applicant is involved in this. If third party represents, PIO must reconsider, but he can only refuse information based on the exemptions of Section 8.1 or Section 9. He cannot refuse it otherwise. Section 23. No court shall entertain any suit, application, or other proceedings in respect of any order made under this Act, and no such order shall be called in question otherwise than by way of an appeal under this Act. Now, Section 23 is routinely being flouted by most courts. People have PIOs approach courts against penalty orders. There is no reason for staying such an order of the commission of imposing a penalty. It is actually only in an appeal that this can be done, and appellate jurisdiction is barred by the law, by Section 23. Only writs can be entertained. The court says we have writ jurisdiction, therefore we'll. But what is a writ and what is an appeal has been clearly defined. In Hari Vishnu Kamath versus Ahmed Sheikh Ishaq in 1955, the following propositions were laid which have not been overturned. 1. Certiorari will be issued for correcting errors of jurisdiction. Certiorari will also be issued within the court or tribunal acts illegally in the exercise of undoubted jurisdiction, as when it decides without giving an opportunity to the parties to be heard or violates the principles of natural justice. The court issuing a writ of certiorari acts in exercise of supervisory and not appellate jurisdiction. One consequence of this is that the court will not review findings of fact reached by the inferior court or tribunal, even if they be erroneous. Even if a penalty order is erroneous, matters of fact cannot be argued in a court against this. An error in the decision or determination itself may also be amenable to a writ of certiorari if it is a manifest error apparent on the face of the proceedings. For example, it is based on clear ignorance or disregard of the provisions of the law. In other words, it is a patent error which can be corrected by certiorari, but not a mere wrong decision. We got about 15 information commissioners to write to the Chief Justice of India, saying that this is wrong and this must be stopped. Unnecessarily, high courts are, they just call an appeal as writ and they accept it. This needs to change. What you can do. In appeals, argue that the exemption does not apply. In case appellate authority does not agree, insist that you should refute your points of law and put it in the order. Argue on the law and say this exemption does not apply. In most cases, avoid trying to justify disclosure in larger public interest. It works very rarely. Because, please understand the legal position. You need to justify larger public interest only when an exemption applies, not otherwise. When exemption applies, then you may still argue that there's a larger public interest in disclosure. So effectively, you are conceding that a harm that to an interest that should be protected by law is going to occur, but there's a larger public interest, so it's a balancing act. Very few orders will be there where somebody says, I believe this exemption applies, but there's a larger public interest in disclosure. What kind of case could this be? Arbitrarily, I am saying, supposing you ask for Modi's transactions with Punjab National Bank, they would claim legitimately that it's fiduciary relationship and therefore they will not give it. You may be able to argue that there's a larger scandal that has occurred and therefore there's a larger public interest in disclosure. Only such matters will happen. Do not concede that an exemption applies. If an exemption applies and you are convinced, do not go into appeals. Don't just say it's in larger public interest. You are not likely to succeed. Raise a demand for RTI applications and responses to be put up on websites with word search facilities. These should be searchable by PIO name, applicant name, department, and subject. Transparency for everyone is the desired goal. The DOPT had also started this, but now it's not happening. Getting a portal like Jan Sutna portal, Rajasthan has given an outstanding example. There was Jan Sutna portal which gives lots of information down to ration cards, down to rationing issued to individual people. And this is all available on the portal by village name, person's name, etc. And there are a host of things that are available. Karnataka also, I believe, is following something like that. And I wish all other states were to get this kind of facility. All dashboards should be seen and open to viewing by citizens. As just one example, and this example must be there in lots of places, MCGM has a SAP system by which dashboards of certain data is available, is open for viewing to the government officers. Unless something is exempt, it should be open to be seen by citizens also. That would be a good monitoring check on the government functioning. Monitor the work of the Information Commission. I think that is necessary. Citizens say, ये decision ठीक नहीं था, वो decision ठीक नहीं था, ये बहुत अच्छा था. This is individual. Who is assessing the work of these commissions? Nobody. My submission is 1 or 2 law colleges or bar associations should take ownership of this and issue a report every 2 months on each information commissioner's performance. That would act as a pressure and also help to get the law probably affected properly. Try and get the information commissions to dispose cases in a time-bound manner. This, I believe, is very important. A law that promised to ensure that you will get information in 30 days or maximum another 45 days from the information from the first appellate authority is lingering for years nowadays, 1 year, 2 years, 3 years with the information commissions. This must be ensured. There are 3 High Court decisions that say that commissions must decide within 45 days. I personally feel 45 days is too tight, but it should be at least 90 days, and rare cases only should take more than 90 days. 90 days, 120 days at maximum. Madhya Pradesh has a rule put in it saying that information, the commission must decide within 180 days. That is also being flouted. Hold web meetings to discuss RTI issues. This is another suggestion for citizens. I think citizens are not doing adequate work to defend their fundamental right. In case of attack suspected to be because of using RTI, Information Commission must order disclosure of all the information sought by the victim on the website of the departments. Persuade your commissions to do this. I had issued such orders as a commissioner. I had also persuaded Mr. Ratnagar Gaikwad to issue such an order. Use section 18(1)(f) to ask for specific information on the website. You can say that this information should be available suo motu on the website. Give a format and request your commissioners to issue orders. Most of such orders are not challenged. I had issued over 140 such orders, and this can become the norm. Keep raising the demand for 11 information commissioners for Maharashtra. Try and get this commitment from political parties with the promise to ensure no position is left vacant. Maharashtra is suffering very badly. Right now, it has got over 1 lakh appeals and complaints, and at the rate at which it is going, Information Commission will become a history commission. Instead of information, what people will get is history. RTI, right to information, has been converted into right to history, which needs to stop. Raise the demand that information commissioners must dispose at least 6,500 cases in a year, giving the option of video conferencing to appellants and officials, and must ensure time-bound disposal for 95% cases. Incidentally, in Maharashtra, government GR has been issued, saying that all quasi-judicial hearings must offer the scope of virtual hearings to the citizens and to the government officers. Insist on this. If you like, write to me. I'll send you the GR issued by government. Insists that before the shortlist for selecting information commissioners is sent to the CM committee, one interview should be open to public. This, I think, may help us to get better commissioners and commissioners who are committed to really transparency. RTI activists should apply for information commissioner's position. Very few I was a rare person selected at random by a random process, but I think RTI must get information commissioners who are committed to information transparency. Some sources where you can look at these 200 RTI are genuine striking down illegal interpretation of exemptions are available at this website link. On the CIC website also you can get all orders, but it will give you a whole lot of orders. If you want to access the orders that are mentioned here, Guide for Appeals, www.satyamevajayate.info. This is my own website, and you can access Guide for Appeals. Use RTI to make our democracy more meaningful. This is not a democracy. You, the citizen, must monitor the government and use it as to defend your fundamental right. We are not defending our fundamental right, and we are allowing wayward decisions by everybody. We oppose when the political class tries to amend the law, but we do not oppose illegal, unconstitutional amendments to the law by misinterpreting, misreading. In fact, our parliament has given us one of the best laws. In my opinion, it is perhaps the best law in the world. But in implementation, we are far poor. And I think to some extent, citizens must take some interest more than they are doing today. This is a slogan which I often share. Those who have heard me before will be aware of this. Mera Bharat Mahan, we say. But we don't really believe it, do we? Therefore, I say, Mera Bharat Mahan nahi hai. Mera Bharat Mahan nahi hai, par ye dosh mera hai. I, the individual sovereign citizen of this nation, am responsible. And I must take responsibility to correct things, to make things better. It is my flaw if the country doesn't become better. These are sources. You can get a copy of this presentation from Moneylife. Akshay Naik will probably tell you how to get this.
Thank you, sir, for the presentation. If anybody wants a PPT, they can send us a mail on foundation@moneylife.in. So we'll take questions now. If you want to ask a question, please use the raise hands button on Zoom and I'll unmute you. Mr. Rohit Agarwal, I'm unmuting you.
Good evening, Sir Rohit. Yeah, I've spoken to you before. Thank you so much, and it was actually very enlightening. So, if you remember, I had spoken to you. I had a house break on 22nd September last year. Tomorrow it will be complete 1 year, and I'd asked for camera recordings, video camera recordings of the police station. I filed 3 RTIs. After first appeal, I could not go into second appeal. I had multiple hospitalizations, so it's remained. Earlier also, there have been similar RTIs where I got the order by the CIC. That was the gas subsidy. That was in 2011. But they did not give me the response, the Bharat Petroleum. Now, what happens is either we stop after second appeal or first appeal, or the replies are not given. I just thought if there's one solution which we could do, because I filed writ petition in the High Court, if we can file a contempt of court or fraud, because with your help, I had at the time of making an RTI application, I had also given them the judgment copies of division bench of Supreme Court that the video recordings of the police station has to be preserved for 14 months. And in case of any discrepancy or any kind of a complaint, it should be preserved for a longer period. Audio and video recordings. Now, there are several Supreme Court judgments that if the precedents are not acted upon or if the Supreme Court judgments are not followed, it amounts to contempt of court. Yet, these people, like, crime ho raha hai, and as you said, it's going to be history. Means these people, they get away. Ek RTI ke andar aadmi mar jata hai. I'm out of the house. I'm in a bad shape. I can't even speak about it. मैं मतलब unstable हो चुका हूँ. मतलब in a homicidal state. अब आदमी कितने RTIs फाइल करेगा? Because that one RTI drains you down. तो इसका मेरे को खाली ये पूछने का था आपसे. मेन मेरे को ये था. I would not take much of your time. is there any way where, kind of, if we file an RTI and at the first instance itself, we cannot fight the entire system because नीचे से ऊपर तक corruption है. So at the time of first appeal or at the time of filing the RTI, we make these presentations along with the Supreme Court and the Apex Court judgments and then say in case if that's not allowed, we proceed to the court with contempt of court application or fraud, because fraud mein kya, there's a summary trial in any case, because a layman cannot go so far. Means on here, my certificates, everything is lying in the house. मैं कुछ नहीं कर पा रहा हूँ, sir.
Rohit, I empathize with you, but I do not want to offer you any sweet solutions. Courts can be equally draining. We need to come to a system, and that's a larger issue. All judicial and post-judicial things must be time-bound. We've got into a habit of saying everything you may go to a court, it's like a lottery, you may get a fast decision, you may get a decision after 10 years. So I would not suggest anything like that. Make your own choices is all I would say. I'm not too sure if the courts are the right. I'm focusing on right to information. I'm saying if enough RTI users start forcing the issue, maybe things will improve, and we have no choice but to make it work and to make it better. And I'm sorry, Rohit, but I'm not able to offer you anything further.
We'll take the next question. Mr. Amit Gupta, I'm unmuting you.
Sir, my suggestion is the PPT which you have shown. So when I placed RTIs, there are the very layman rejections, like it's a third-party information, it's a personal confidential information. This information is available on so-and-so website, so-and-so link. Please visit there. Something like that, right? So can you prepare something like, a standard format? If we get such type of rejections like a third party information, so what things we have to put in the first appeal, so that will be a clearly hit to them, to the appeal first appeal authority. And because first appeal authority is from the same department, so mostly they are also going to be favored with the SPIO, the Rajya Lok Suchna Adhikari. So mostly they are also be in that tuning. Okay, fine, this is so something we have a proper in a way, like, okay, I can also present the some judgments or some kind of rules. So but we have some standard format, okay, with respect to this third party or larger public interest or confidential or website link, it is available, it's just go there and read it or something like that. It's a very disappointing.
Amit ji, on my website www.satyamevajayate.info, I've made a guide. It's in English, and somebody is also done a Hindi translation. I can't guarantee the Hindi translation, but the English translation I'm responsible for, which does precisely what you are requesting. So try that website. There is a guide there available. You can download it free of charge without any problems and use it. Download it on your computer and you will find it useful to use whenever. That was the whole intention. Thank you, Mr. Amit.
We'll go to the next question. Mr. Ashish Das, I'm unmuting you.
Hello, thank you, Shailesh ji, for your excellent talk. My basic question is one. I read one of your lines which said that in RTI, one can only seek what is on record. Okay. And we are talking about only public authorities. So this being said, I also want to bring to your notice the definition of information under 2F, where it says that information means any material in any form and information relating to any private body which can be accessed, right? Which can be accessed by a public authority under any other law for the time being in force. So I just wanted to know the conflict between information which is on record vis-a-vis the information is not on record, but as per the definition of information, it can be accessed and therefore from a private body under a law. So I just wanted your opinion on this.
Let me clarify. On record, the record may be held by the public authority or may be held by a private body. But it still has to exist. If you say, supposing I apply for this job, will I get it? There'll be no record of it. So you are muted, Ashishji. You are muted. Ashishji, you are muted. I can't hear.
Ashishji, let Gandhi sir answer first, and then we'll take up your follow-up question. So you can continue.
So what is existing is information. I mean, I also amplify it many times and say what exists is information. Now the issue is, from a private body, can I access the information? Directly I can't, because they are not covered by the RTI bit. Now these words under law, which can be accessed under law in the time being. There are two ways of looking at it. One is to say, when you read, you can access everything. The other way that most of us interpret, and I think that's a rational interpretation, is that what normally the private body is supposed to give to the public authority can be accessed from there. Even if the public authority has not accessed the information, then he is forced to access the information and give it to the person. But things that under normal rules and laws he is not expected to access from private body, that is not covered.
We'll move to the next question. Mr. Virendra Sharma, I'm unmuting you.
Hello. Good evening, Shailesh sir. Sir, I will put forth first my point in chronology, and then I will ask you two simple questions.
Sir, you can ask, sir, 1 second. We'll ask only one question. We don't have time to go through a lot of questions. So
okay. Sir, under section 6(1) मैंने RTI एप्लीकेशन फाइल किया था. उसके बाद मैंने 19(1) के तहत मैंने फर्स्ट अपील फाइल किया. तो PIO ने मुझे 30 डेज के अंदर रिप्लाई नहीं दिया. तो अंडर सेक्शन 7(6) I was entitled to obtain information free of cost. So तो सर मतलब फर्स्ट अपील के अंदर जो फर्स्ट अपील ने ऑर्डर दिया, उन्होंने ये कहा कि भाई आप फोटोकॉपीज ले सकते हो, बट नॉट 2000 पेजेस 500 पेजेस. तो मतलब क्या लिमिट है कि भाई इतने पेजेस मिल सकते हैं? क्योंकि जो BPL वाले लोग होते हैं,
ऐसी कोई लिमिट नहीं है.
ओके सर, लिमिट नहीं है.
But yes, I think things have to be slightly reasonable. You cannot suddenly, what you had sought, relating to that you can. I mean, there's a balancing that has to be carried out by a commission or appellate authority, saying कितना reasonableness आपको information. अगर आपने बहुत सारा मांग लिया है, दुनिया भर का, जैसे 10 साल का मांग लिया है, तो but there is, by law there is no definition of extent that you can get free. By law, even 50,000 pages should be available free, as the law goes.
Okay, we'll take the next question. Mr. Sumit Kansal, I'm unmuting you.
Many thanks, Gandhi sir. And in fact, your journey has been very fascinating from coming from the entrepreneurship to activist and this journey. Wonderful, sir. I'll just have one question that many a times PIOs on one frivolous ground or the other are denying the information, and the only recourse is going to the commission, is what I feel. So I have not, I am a CA turned lawyer and not dealt much practically into the RTI law. As per your experience, how effective, because I see that FAA generally don't give the information at all when we go to the first appeal, or we only need to go to the commission. How effective would be going to the commission? And that is the only question, because a PIO, I asked a question under 2J says that questions like where, how, when will not be answered. How correct would that be, and how effective is it?
That's an incorrect position to take. just because there's a question mark, a lot of commission. That's what I'm talking of. I did not cover that today. There are lots of things which I call illegal denial of information because there's a question mark. But the question is there a record? If there's no record and you say, नहीं, मैंने पूछा इसके लिए आप पता लगा के लाओ, that is wrong. If, let me put it like this, supposing there's an illegal building constructed opposite the PIO's office, but on record the building doesn't exist. And if you say, ये plot पे कौन सा building है, if he answers there's no building as per record, he is right. What is on record is to be given, not something, but just if there's a question saying who's the head of this organization, let's say, why did this action take place? Why did such an order be given? Unless there is a record, if there is a record, it must be provided. There is no record, he is not expected to generate a record.
Okay, we'll take two more questions and then we'll end it for the night. Mr. Neeraj Rai, I am unmuting you.
नमस्कार सर, मेरे साथ प्रॉब्लम ये है कि कई जगहों पे, जैसे मैं ये जानना चाहता हूँ कि कई जगहों पे आरटीआई लगाते हैं जब हम, तो हमें पीआईओ या सीपीआईओ जो भी होते हैं वो एक स्टैंडर्ड रिप्लाई करते हैं कि फाइल मिल नहीं रही है या जानकारी मिल नहीं रही है जो आपने मांगी है। तो मुझे ये जानना है कि इसका क्या कुछ ट्रीटमेंट है क्या, जो मतलब जो इसका कुछ काउंटर है, क्योंकि ये
हाँ मैं समझ गया। इसका काउंटर ये है कि फर्स्ट अपील में जब जाएं तो कहिए कि पहले इसकी कंप्लेंट कीजिए पुलिस में, नहीं मिल रहा है या चोरी हो गया कैसे पता, अगर आपको पता है कहाँ है तो मुझे दीजिए इंफॉर्मेशन। अगर आपको नहीं मिल रहा है तो मैं कह रहा हूं चोरी हो गई और आप चोरी का कंप्लेंट लिखा के आइए पुलिस में, तो बाद में वो उसको रीजनरेट नहीं कर सकते हैं। कभी कभी मिल जाती है इंफॉर्मेशन, कभी कभी सचमुच गो हो गई होती है। ये दोनों चीजें होती है, मैं मना नहीं कर रहा हूं। जिस तरह सरकारी रिकॉर्ड्स रखे जाते हैं इसका सोल्यूशन भी है, सिंपल है। पेपर फाइल्स के बजाय कंप्यूटराइज फाइल्स अगर हो तो ये गुम होना वगैरह नहीं मिलना बंद हो जाएगा, बट वो हो नहीं रहा है। बट इसका एक तोड़ ये है, कानून में नहीं लिखा है बट कमिश्नर्स भी कई बार करते हैं, मैं भी कई बार करता हूं, नहीं मिलता है तो वो बोलेगा 5 साल से है या 10 साल से है, तो मैं तो था भी नहीं उस टाइम इस ऑफिस में, तो उसको जिम्मेदार किसी को ठहराना गलत हो जाएगा। बट ये इंसिस्ट करते थे, मैं भी इंसिस्ट करता था कि पुलिस कंप्लेंट दो और पुलिस कंप्लेंट की कॉपी एप्लीकेंट को दे दो और मुझे दो। तो ये, और कभी कभी वो बाद में अगर वो नई गलती से बोल रहे हैं तो बोलते नहीं सर मिल गया फाइल, तो रिकॉर्ड दे देते हैं। दोनों चीज होती है।
Ms. Shubha Khandekar, you wanted to ask a question, or I'm meeting you.
Hello.
Yes,
Hello,
ma'am.
can you hear me?
Yes, yes.
Yes, ma'am.
Mr. Gandhi, thanks for a very informative session. I want to ask you, in case the government has the information, such as email correspondence of crucial value from an individual, but it denies that it has the correspondence, then in that case, what should we do?
See, unless you are able to give substantive evidence of having it, there is no way. I mean, ultimately, everything does not get solved. All Beimani cannot get solved by RTI. If people are liars, which is what you are indicating, and which does happen, I'm not disputing that. But unless you show a commissioner that this is clear evidence that the material exists, there is nothing one has to accept it at face value. At best, a commissioner, if he feels some doubt, he may ask for an affidavit to be given. Beyond that, there is nothing that can be done.
We'll take a question from there's a question from Mr. Rahul Maisakar. I'm unmuting you. Rahul ji?
Yes, sir. Am I audible?
Yes.
Yes.
Sir, this question is related to matrimonial cases, and of course it is related to me. मुझे वो महिला सेल जो होता है उससे एक समझ जो मिलता है उसका आया था एंड उसके रिप्लाई में मैंने RTI फाइल किया था कि मुझे किस तरह की केसेस फाइल है वो और केसेस के डॉक्यूमेंट्स मुझे मिल जाए. So the reply I got that we have case against you, but we cannot give you the complaint copy because उससे जो complainant है उसको उसके जान को जीवित हानि वगैरह हो सकता है. 8(6) it was the point, and then I appealed. और अपील में ये कहा गया कि because that particular cell is operated by police, but it is private cell and private अगर है तो हम उन पे जबरदस्ती नहीं कर सकते. So how to tackle with this?
No, I repeat what I said. Information can be denied based on the exemptions only. Husband है, wife है, उसका कोई मतलब नहीं है. क्या dispute है, उसका भी कोई लेना देना नहीं है. सवाल ये है कि अगर exemption लागू होता है, अभी उन्होंने कहा आपको कि भाई endanger life, अब वो endanger होगा नहीं होगा मैं नहीं जानता हूँ. मैं आपको जानता हूँ ना आपकी वाइफ को जानता हूँ. ये फिर आपको आर्ग्यू करना चाहिए कि मैं कभी इसको endanger कर ही नहीं सकता, मैं ऐसा आदमी हूँ. इसके बारे में तो और कोई चारा मुझे दिखाई नहीं मिलता.
We'll take a last question from Indranil Bhattacharya. I'm unmuting you.
Hello, can you hear me?
Yes.
Yeah, many thanks for this wonderful presentation, Mr. Gandhi. I have been dealing with a very peculiar case where there is a particular PIO and an FAA who are working in tandem, and they've been refusing information, citing very frivolous things like this information is not relevant to you, this information falls under, it's a third party, they're invoking the third party clause, etc. And they're doing it in a serial way. I have got, 7-8 such orders. I think they're doing it just to delay the information. One case went to CIC, and the CIC very strangely, I was expecting that, CIC rebukes them or imposes some penalty. So I was wondering if one can file some kind of a complaint under the complaint section of the RTI, clause of the RTI Act. Will it be treated separately? What is your advice?
No, the complaint also has the same waiting period as the appeals in most cases, as far as I know. Therefore, the complaint, and unfortunately, because of what I call a bad Supreme Court order, when you go in complaint, the commission cannot order information to be given to you. That's the Supreme Court order, which I disagree with, but that's there. So most commissioners would accept that and say they can't give you information. But your option is, the real option is that we must struggle to ensure that we get better commissions, we get time-bound delivery of justice. If that happens, then I think all of this will resolve. Otherwise, right now, you have no option except to go to the commission and wait for CIC. I think the wait is between 1 and 2 years, as far as I am aware.
All right, I think we are done with questions, so I think we'll end it here for tonight. Thank you so much for the presentation, Mr. Gandhi. Thank you everyone for joining. If you would like a copy of the presentation, you can send us an email on the email ID that I've shared in the chat. It's foundation@moneylife.in. We also have an RTI advice app. So if you have any further questions you want to ask, you can download the app and ask any questions on the app itself. So thank you everyone and have a good night.
Thank you. Thanks to everyone.